We're in Seminole County, Florida, for the arraignment of 74-year-old Mark Schmitter. He's accused of trespassing and resisting an officer without violence. 1 month earlier, Schmitter entered Jason's Deli in Altamont Springs wearing a protective face mask, but later approached the self-serve salad bar without the mask, violating the restaurant's COVID policy. When asked to put the mask back on, members of the deli staff say Schmitter refused. For his part, Schmitter claims he wasn't given the chance to comply before they told him to leave. Schmitter claims his constitutional rights were being violated and insisted the police be called. Officers arrived to investigate.
Yeah, you should probably record the whole thing that everybody knows.
Well, sir, I just spoke with the manager there.
Right.
They've asked you to leave.
They demanded I leave.
Right. Are you gonna leave?
No.
You understand that's a crime in the state of Florida. You can be arrested for that.
No. They have to, first of all, issue a no trespassing order.
That's the warning right there. What's your first name?
I'd rather not give my name.
I'm just, what do you want me to call you?
Call me Honey.
Schmitter argues that the restaurant cannot kick him out since it's open to the public, but he's mistaken. It's private property, and the owners have the right to demand he leave. The officers try to convince Schmitter to comply, but he is not ready to go.
You have your ID on you?
No, I never carry ID.
Okay. My patience is running thin. If you're not going to give me your name and date of birth, you're going to go to jail.
Honey, I'm not fighting you here.
No, we're not saying
Listen,
war,
sir.
but
Listen,
you're
sir.
not-
I'm going to ask for your name and date of birth when I click my pen, and if you do not tell me, you're going to jail. Is that worth it?
I got another question, may I?
What is your name?
How do you know if I'm giving you the right one?
I'm done.
Okay, wait a minute. I got another question.
No, I'm done.
870.
Stand up for me, turn around, and place your hands behind your back.
I'm not resisting. I'm not resisting a federal law because I'm a fight you.
I give you every opportunity.
Schmitter was arrested and released on a $1,000 bond. Today, he's in court in front of Judge Frederick Schott for arraignment, where he must enter a plea.
And Mr. Schmitter, you're with us.
I'm here on special appearance with a natural person with my name lawfully and properly spelled in upper and lowercase letters.
All right, well, on your birth certificate it said Mark Edward Schmitter, right?
Yeah, but it's in capital letters and that's a fraud.
I know you got stuff off the internet to ask so that you can try and get out of this. None of that works, okay? You are part of our country. You are part of our county.
Schmitter has chosen to represent himself, but he's assigned a public defender as standby attorney. The prosecutor offers a plea deal to avoid a trial.
Counsel, is there an offer to Mr. Schmitter today?
Yes, Your Honor. 6 months of supervised probation, 20 hours of community service, and a letter of apology to the police officer.
And Judge Schott exercises his right to make his own deal.
From me, today only. You pay $263, you write a letter, and you're all done. No probation, no jail, no community service. What option would you like today?
No, I just soon go to court.
You want to try? Okay.
Schmitter's public defender throws down his pen in disbelief that his client is rejecting the judge's deal.
Okay, the charges are a trespass in a structure or conveyance consisting of a refusal to depart Jason's Deli, punishable up to 60 days in jail, and the charge of resisting an officer without violence.
I don't understand the nature of the cause of the charges.
Well, your attorney will be happy to explain
I
it.
don't want an attorney.
I just explained it to you.
I object.
The judge tries to move on to the point of today's hearing, entering a plea.
Are you going to plead no contest or are you going to plead not guilty?
I don't understand the charges. I can't.
Yes, you do.
No, I don't.
Then you have to enter a plea.
No, I don't have to enter a plea.
If you refuse to enter a plea today, no matter what I do, I'm going to remand you.
Your Honor, may I have 2 minutes with Mr. Schmitter?
Schmitter's public defender takes him outside for a conference. He returns with a new strategy.
Under duress and under threat of jail, I make a plea of not guilty.
Finally, a plea is entered, and the hearing ends. Schmitter is free on bond, awaiting trial.
Will you produce the document that has my signature that gives you jurisdiction? Will you produce that?
We're in Concord, New Hampshire, and the man bellowing at the judge is 85-year-old State Representative Dick Marple. A year earlier, the New Hampshire lawmaker was charged with driving after having his license suspended.
Please rise. Congressman, your court is now in session.
Today is the first day of trial, but this simple suspended license case might not be so simple after all.
State versus A. Marple.
You might notice Marple is not at the defense table, and that's because as a sovereign citizen, he does not believe the court or Judge Kristen Spath have jurisdiction over him.
State ready to proceed. We are in the call for space.
Madam Magistrate,
Yes.
I am here under threat, duress, and coercion. I'm not here because of an order, because you as a magistrate cannot make an order. You can only administer ministerial duties. You have no jurisdiction to judge your own jurisdiction.
Judge Spath then calmly explains the legal steps Marple can take to contest her jurisdiction after the trial is complete.
You will have an absolute right to appeal my decision.
You have no decision because you don't have any jurisdiction. You come out with what's called an order. You can't make an order because you're not a judge.
Well, Mr. Marple,
You are acting in an administrative capacity.
I continue to disagree with you.
There's no question of agreeing with the question of the law. You either obey the law or you are in violation of your oath of office.
After taking a couple of personal shots on the chin, Judge Spath once again tries to restore decorum in the courtroom.
I have 2 requests. One is that when I wish to speak, that you give me that courtesy. And when you wish to speak, I will do the same. As long as we continue to be discussing what is relevant to today's case.
There is no relevance to today's case because you don't have jurisdiction.
Not only does Marple argue the court lacks jurisdiction, but he also claims the state has no authority to police his driving in the first place.
RSA 382A 9-109 defines the automobile as consumer goods. Consumer goods do not have to be registered. Consumer goods do not have to have a, quote, license, unquote, in order to travel.
And speaking of driver's licenses, Marple doesn't believe in those either.
It's not a license. It is a photo ID that I purchased.
Still, Marple wants his back in his wallet.
I want my property back.
All right, well, that is.
I asked for it 4 times. You refused to give it to me.
Well,
That's conversion.
all right.
That is conversion. Criminal conversion.
And finally, the state representative lays it all on the line.
All right,
There's going to be a stop to it. Are you going to recuse yourself? I ask you that.
I am not going to recuse
You're not going to
myself.
recuse yourself.
I do not believe there is any valid reason for me to recuse myself. I believe that I have been fair and impartial. I can continue to be fair and impartial. We are scheduled for a trial today, and I want to let you know that the trial is going to occur today. I would urge you to participate in the trial.
I'm not participating in something that cannot exist. It is a total fraud.
The trial would proceed, but after he continues to disrupt the proceedings,
The principle is the people that I represent are being ripped off. That's what it's all about. And if you're going to continue with this, you will be paying the penalty, I assure you.
Judge Spath simply walks out of the courtroom. State Representative Dick Marple would ultimately receive a judgment of guilt through the mail and was ordered to pay a $310 fine for driving with a suspended license. Next, we're in the Broward County Bond Court in Fort Lauderdale, Florida.
Go ahead, ma'am.
Mr. Shanus, Abraham Arthur Shanus, and I have been legally divorced for 31 years,
Okay.
and I have the papers to prove it.
This is 80-year-old Dolores Shinus. She landed herself in jail for resisting arrest after violating a restraining order filed by her ex-husband.
We both resided at 20 Bend, and he paid for the apartment entirely. His assumption is because he paid for the apartment, he's entitled to do as he pleases.
I can't get in the middle of who owns the apartment.
I know, that's not the point.
My
The point I'm
is,
telling you,
I need to keep you away from him, all right?
I haven't bothered him for 31 years. Why would I bother him now?
Rather than actually getting up in arms, Judge John Hurley decides to release Shinus on a personal recognizance bond, so long as she agrees to stay away from her ex-husband.
You are not allowed to call him, text him, email him. You are to stay 500 feet from him at all times. That's where he lives, where he works, anywhere in between. Ma'am, you're getting a second chance on this case. I don't particularly feel like keeping an 80-year-old woman in the jail who has no criminal record. But this is your second warning. Don't go around him again.
I swear to God and all that's holy on a stack of Bibles, I will never go near him, talk to him, call him, or
What was
even
the
look
first
at him.
thing you were going to swear on besides the Bibles?
All that's holy.
What?
I don't remember.
Oh.
What?
All that's holy.
All
What?
that's
Totally?
holy. Yeah.
Oh, all that's holy, yes, sir. I didn't recognize your twang.
The senior's sassy remark catches Judge Hurley off guard.
Ma'am, have you ever thought of doing a stand-up routine? Have you ever thought about that?
I did. Well, if you pay me good money, sweetheart, I'll be there. I'm really short of funds.
Ma'am, I got to tell you something. You seem like you have a great wit about you.
I do, sir.
Yeah, so...
I mean, sweetheart, that's the only thing I have.
I've been called sweetheart in this courtroom.
Does that mean you're taking me for breakfast?
Let me ask you something, ma'am.
Yes, sir.
How have I done as a judge today? So far, how am I doing?
Not bad, but you could do better.
Can we get a drum roll with this?
With the case already wrapped up, the only thing the judge, the public defender, and all the other inmates are waiting for is one final punchline.
I got to tell you, you brighten my day, ma'am. All right?
That's what the last guy said, and then he sued me.
Good morning. Are you Virginia Wagner?
I'm Miss Wagner.
Next, we head to Lawrenceburg, Kentucky. The defendant, 85-year-old Virginia Wagner. The charge? Reckless driving and driving with a suspended license. The vehicle? A souped-up Dodge Dart.
You had that
race car.
You had that fast car. I know you did. You didn't need that fast car.
Wagner doesn't refute the charge, but places most of the blame on the car itself.
I'm sorry it happened, but the car that I was driving was like a race car. It had an extra motor in it. The car is not going to be driving anymore.
Okay. I would recommend a $100 fine.
All right. You understand the offer from the Commonwealth is that you would plead guilty to operating on a suspended license and you would have to pay a $100 fine?
I know it now.
Okay, did you understand though that, do you want to accept that and plead guilty today?
Yes, I'm guilty, yeah.
As a packed gallery looks on, Wagner finishes up her business. That is, until
Yes, sir.
an unusual request is submitted to the judge.
Ma'am, he wants to pay your fine.
A good Samaritan who gave his name as Mike Evans offered to pay Wagner's fine.
So, Miss Wagner, you go down.
Just sit here and I just take the paper.
Yeah, you give him your paper and he's gonna go down there and pay that for you. Thank you, sir.
Wagner appreciated the man's generosity, but after initially accepting his money, she later returned the cash, paid the fine herself, bringing an end to Virginia Wagner's time behind the wheel. We're in Versailles, Kentucky for a circuit court sentencing hearing. 66-year-old Vicki Brodigan has entered an Alford plea to manslaughter in the death of her ex-boyfriend. This means she didn't admit guilt, but acknowledged there was enough evidence to convict her of the manslaughter charge. Almost 2 years earlier, 66-year-old David Clark was found shot to death in his home. Investigators connected Brodigan to the shooting and then found evidence that she may have previously made 2 additional attempts to kill David by putting eye drops and Viagra in his coffee. A grand jury indicted her on charges of murder, burglary, evidence tampering, and 2 counts of attempted murder for the earlier incidents. Brodigan's attorney negotiated a deal for her client to plead to a lesser charge of manslaughter. Today, she's before Judge Jeremy Maddox for sentencing.
Ms. Brodigan, on the second day of March 2022, you appeared in court with your counsel. You entered a guilty plea to the amended count of manslaughter in the first degree, a Class B felony. Commonwealth made a recommendation at that time that you be sentenced to 10 years to serve. You were advised the court not to follow that recommendation. You would be allowed to withdraw your guilty plea. Ma'am, do you remember these events and did you understand them?
Yes, sir.
Also in court today is David Clark's daughter, who stands with the prosecutor, Commonwealth's attorney Sharon Muse.
The next of kin of the victim is here. Is she wishing to speak or read her victim impact statement?
She previously said no.
I just want her to die.
Well, she's not eligible for the death penalty, and I can't carry out an execution in the courthouse. Ms. Brodigan, before the court pronounces its sentence, would your attorney like to make any statements to the court on your behalf?
No, Judge.
Although both sides have agreed to a 10-year sentence in exchange for the plea, Judge Maddox is not bound by this deal. He has the authority to impose a harsher sentence solely at his discretion.
Ma'am, I can't, with this admitted charge that she's pled guilty to, I cannot give her a life sentence. I just can't do that. I know your father is dead, and I can't do anything to bring him back. Someone's lost their life here. I cannot give her life in prison, but I don't have to follow the 10 years either. So therefore, the defendant is sentenced to 20 years.
The gallery erupts in spontaneous applause when the judge exercises his right to set aside the recommended sentence and impose his own. Brodigan is sentenced to 20 years instead of the 10 she was expecting when she walked into court today. Attorneys on both sides are stunned. The prosecution attempts to save the deal, which was negotiated with the approval of the victim's family.
Your Honor, I would ask you to consider that this was a mediated agreement with...
I understand that.
So they're going to withdraw their plea?
Yes.
Okay.
With the change of sentence, the defense opts to withdraw Brodigan's plea. This means the case will now go to trial, something the victim's family was hoping to avoid.
We don't want to go to trial.
I understand that, but as the presiding judge in this, we have, someone is dead, and someone's life is worth more than 10 years. And this goes to every case that comes before this court. And it's my job to make that determination. And
will you be our judge?
Yes, ma'am. Thank you. We don't need that. This isn't a taping of The Price is Right.
Brodigan now faces trial on the original charges of murder, attempted murder, burglary, and evidence tampering. She remains in jail awaiting trial. Our next stop is inside Franklin County Common Pleas Court in Columbus, Ohio. for the sentencing in the disturbing case against 70-year-old Terry McFadden.
You will be a Tier 3 registrant for your lifetime with in-person verification every 90 days.
2 months earlier, McFadden, who worked at a residential daycare business run by his wife, pled guilty to 2 counts of rape. The victims were attendees of the daycare, 2 young sisters, only 4 and 6 years old at the time.
Terry McFadden is a psychopath who raped our girls, fooled us, fooled 25 years worth of families in his wife's daycare. He's a skilled pedophile and a sociopath.
After an emotionally charged statement from the girl's mother that had McFadden shaking his head, Judge Julie Lynch also gives him an opportunity to speak prior to sentencing.
I apologize to the victims, to the 2 little girls. I hope to become to work to become a better person and when I have served my complete sentence.
But McFadden's apology falls on deaf ears.
This court is so sick and tired of seeing adults ruin and abuse children. These are literally just one step from being babies. They come to a daycare, those parents struggle so that when they release their children to someone during the day, they have some semblance that that child is going to be protected and safe. Not let alone 2 of their children being raped by your own admission, sir. For sexual gratification, you violated a 4-year-old and a 6-year-old. I do not know at this time what the total ramifications will be for those 2 young children, but there isn't anybody who doesn't understand now the developmental phases of children take place from 0 to 6 years old. You can't even know what damages you've done for sexual gratification. This, to me, is so mind-boggling that you used and abused 2 little children like they're inconsequential beings. Those are human persons with human dignity. I'm going to tell you something, Mr. McFadden. There's no free rapes in my courtroom.
And with that, the judge sentences McFadden.
On count 1, I'm sending you to prison for 11 years. On count 4, I'm sending you to prison for 11 years. They will be consecutive to each other for a total of 22 years.
The horrifying case comes to an end. But before dismissing the court, Judge Lynch issues one last powerful reminder to all.
Folks, if you see it, you smell it, you know it's happening, you report it. And this ends in this courtroom. That'll be all.
All rise. The court is now in session.
We take you inside the 6th Judicial Court in Pasco County, Florida. The defendant is Dale Massett, the former mayor of Port Richey, Florida. He's pled guilty to aggravated assault on a law enforcement officer with a firearm, weapons charges, and resisting arrest. 2 years earlier, Massett was at home with his girlfriend when a SWAT unit arrived to execute a warrant for practicing medicine without a license. The charges coming at the end of a 4-month investigation.
Sheriff's office, search warrant, come to the door!
The 70-year-old former mayor is also a former doctor, having had his license revoked back in 1992. Massett was also known to own several guns, so the officers were on high alert.
Sheriff's office, search warrant, come to the door!
After they identified themselves multiple times, there was still no sign of Massett. So the officers decided it was time to go in.
Sheriff's office, search warrant! Sheriff's office, search warrant, come to the door! Sheriff's office, search warrant, come to the door!
Massett fired 2 shots at the officers, who quickly responded. After a few minutes, officers finally located Massett.
Dale, put that gun down. Put
Walk toward me, guys. Come on, nice and easy. Take the light off him for a second. All right, walk toward my voice, guys. I'm right here.
Over here. Right here.
Walk toward me. Walk toward me. Take your time, but walk toward me.
Massett and his girlfriend surrendered and were taken into custody.
You have a seat right here on the back of the bus. Sit down.
Hurting me, guys. Why don't you knock on the door and let us know what's happening?
Massett was initially charged with 5 counts of attempted homicide and, if found guilty, could have spent the rest of his life in prison. His attorney tried to have the case dismissed, claiming Massett was standing his ground when the police arrived. When the COVID-19 pandemic hit Florida, many court cases were delayed. So the state offered Massett a deal: plead guilty to lesser charges and serve 3 years in prison plus 10 years probation. Massett accepted the deal, but at his sentencing before Judge Mary Hansel, a number of officers, including Sergeant Billy Lindsay, spoke out about the terrifying events of that night.
I started suffering from anxiety and stress caused by it. To have to go home and tell my family after 20 years in law enforcement that I almost died because a politician decided that it was more important to shoot the first cop that came to arrest him than to lawfully surrender.
Sergeant Lindsay also expressed his feelings about the plea deal that was offered by the state.
The fact that we're here entertaining a plea deal in a case where the defendant is accused of intentionally shooting a firearm at law enforcement officers during the execution of a search warrant is disgusting. Mr. Mossad has clearly exploited the worst flaw in the criminal justice system, and that's that money and political influence buys you freedom if you're rich. He is a true psychopath that lacks guilt, remorse, empathy. He's dishonest, he's a narcissist, and he has no conscience.
And Sergeant Lindsay isn't the only one who believes Massett received a cushy deal. Judge Hansel offers a few words of her own.
For the record, I just want to make sure that it's clear that this was a plea agreement and the court had nothing to do with this, because if I did, I have to agree with the sergeant that Mr. Massett is getting quite a deal.
Massett was sentenced to 3 years in prison with credit for 2 years' time served while awaiting trial, plus 10 years probation. As far as the original charge of practicing medicine without a license, as part of the plea deal, he received a 3-year sentence, which will run concurrently with the assault sentence. Next, we head to Atlanta, Georgia, for the sentencing of Tex McIver. The 75-year-old attorney was found guilty of felony murder in the death of his wife, Diane McIver. The defendant claimed he accidentally shot McIver while driving back from their horse farm. Diane McIver was the president of an airport service company, and prosecutors believe she was killed for her money. McIver pled not guilty, but after a trial lasting 19 days, he was convicted. Before sentencing, friends of the victim make heartfelt statements to a packed courtroom.
The actions have traumatized me. I lost sleep because I so wanted to believe that it was an accident.
This has been one of the saddest and most horrific incidents that has happened in my life. To have lost my friend of over 40 years that was more like a sister than a friend has broken my heart.
Next, it was McIver's turn to speak, which is what he did for 15 bizarre minutes, touching on just about everything. Everything, that is, except the crime.
Last week, on one given day, I received 11 different pieces of mail. One is a lady from Ireland. Then there is the most unique individual I think I've ever corresponded with. His name is Trent Jones. He's a racehorse jockey in Perth, Australia. His favorite racehorse, Hobart, has been retired just this year, and now he and Hobart are free to step into the surf in Perth and play.
The surreal statement continues as McIver moves on to his next subject, thanking his friends in the community.
Friends delivering Chick-fil-A, one of my huge favorites, and one of the things I miss the most
Before he was done, he hit one more subject completely unrelated to the murder, his godson's favorite basketball team.
He's a huge fan of the Golden State Warriors. He said, if anything, I had to say go Warriors before this statement was over with.
Finally, he gets around to discussing the relationship with his late wife of 11 years.
The luckiest day of my life was when Diane chose me. In doing so, we started a relationship that was, can only be described as amazing. We loved each other like small children. We just couldn't believe it was that good.
He goes on to explain just how deep their connection was.
In fact, it became, if people are able to believe it, telepathic. And my conscience would hear these words, is this truly real? She had telepathically communicated those words. Is this truly real? It is truly real. It is truly real.
Before announcing his sentence, Judge Robert McBurney offers a reaction to MacIver's words and peculiar choice of subject matter.
I'll tell you what's most telling. You had as much time as you wanted to share with me what you thought was important for me to hear, and we heard about racehorses in Australia and Chick-fil-A and telepathy. I didn't ever hear you say you're sorry for what you did. To me, that silence speaks volumes.
All that was left was the sentence.
The penalty for felony murder is life. I'm going to sentence you, count 2, to a term of life with the possibility of parole.
MacIver was sentenced to life in prison and is eligible for parole after 30 years when he would be 105 years old. Next, we're in Spokane County Superior Court in Washington State for a first appearance hearing. 81-year-old Howard Patton is accused of custodial interference, criminal impersonation, and forgery. A second-degree kidnapping charge has also been filed against him. 3 days earlier, a social worker notified Spokane police that a teenage girl was missing from her foster home. She'd been placed there after her father, Daniil Bagmet, was arrested and charged with assault for strangling her. It was also determined that her mother, 51-year-old Galina Bagmet, couldn't protect the girl from her father. The foster parents claim that the girl's mother came to their home with Patton, who said he was a lawyer. Patton gave them what appeared to be legal documents that threatened them with execution by firing squad, among other things, if they didn't return the child to Bagmet. The foster parents, who are Russian immigrants, thought the papers were legitimate, so they allowed Patton and Bagmet to take the girl. Police found the teen and her mother at the Bagmet house the next day. The girl was returned to foster care, and Galina was arrested and charged with custodial interference. During the investigation, Patton arrived at the Bagmet home and was also arrested and charged. Daniil Bagmet was not at the house and has not been charged for this incident. Today, Patton is before Spokane Court Commissioner John Stein to determine probable cause in the case and to set bond. Patton, who identifies himself in court papers as a sovereign American national, employs a standard sovereign citizen opener, quibbling over his name as the hearing gets started.
Is this the Howard Patton Trust you're talking about? I'm appearing as a living man.
But the commissioner is having none of it.
Sir, I don't want to hear any of your constitutionalist crap. I mean, just save it for somebody else who's stupid and believes in that. You're here on charges of second-degree kidnapping. I found probable cause for that offense.
But Patton's public defender challenges the probable cause finding on the kidnapping charge.
It's unclear that Mr. Patton was actually the one who took the youth away from the home physically. And I'm looking at these and it's We don't have firing squads. This is not something that is going to happen. And there were no direct threats made other than what was in this paperwork.
Obviously, anybody who's familiar with the court system at all can tell all this paperwork he gave to these people is total nonsense. However, if you're not familiar with court paperwork, and I realize this was a Russian family, they may not know much about the United States, and somebody who claims to be a lawyer handing them what they're claiming is legal documents, threatening them with being deported and property confiscation and all kinds of other malarkey may take it seriously. I will set the $150,000 bond. That's all for today.
2 weeks later, Padden was back in court before a different judge, and this time refused to enter a plea.
I will not enter a plea. That will give you jurisdiction.
So the judge tried to enter a not guilty plea to protect Padden's right to trial.
Is I'm going to enter a plea of not guilty.
You don't have the power, sir. For the record, you do not have the authority to dictate or conduct law from the bench.
Padden remains in Spokane County Jail, awaiting trial. The girl remains in foster care. Her mother, Galina Bagmet, has been released pending trial. Her father, Daniil Bagmet, is free pending his assault trial, but has been ordered to have no contact with his daughter. Next, we head to Taylor, Michigan for a motion hearing. 7 months earlier, 63-year-old Mark Nosel got a ticket for driving 18 miles an hour over the speed limit in a construction zone. If found guilty, he'd be fined $165 and receive 4 points on his driver's license. But the state has agreed to let Nosel plead to a lesser charge of double parking. He'd still be on the hook for the fine, but wouldn't have points added to his license. Today, Nosel appears before Judge Victoria Shackelford because he's decided to reject the plea deal. The judge checks in with Assistant City Prosecutor Amelia Zelenak.
Ms. Zelenak, we are offering the double parking, and if you want to pay that, we have no problem with that. But that's all that we are offering at this time is the double parking.
So when's the court date?
And you'll get notice of that date in the mail.
Will I be offered legal?
It's a civil infraction, sir. You're not given
Well, I'm
counsel
confused
for that.
because they sent that to me in the mail and I had a right to do
The
that.
only way you have a constitutional right to counsel is generally if it's a misdemeanor or there's a possibility of jail time. And there's no possibility of jail time on a civil infraction, so you wouldn't be entitled to a free attorney. But you can retain an attorney, certainly.
Does the court offer me one?
It seems Judge Shackelford is beginning to lose her patience.
What are you confused about, Mr. Nosel? I just explained to you. You do not have a constitutional right to an attorney because this is a civil infraction.
I'm confused. Would you understand why I would be confused when the offer was made to me to call one?
I don't have anything about offering you to retain an attorney.
I got a letter to call an attorney from the city of Taylor that I would have the right to an attorney. That's the confusion. Can I be any more clear?
Sir, I don't know who you think you're talking to, but I'm not going to have you snapping at me and could you be any more clear? I've indicated to you it is a civil infraction. You do not have a constitutional right to an appointed attorney. I don't know what paperwork you received from the city of Taylor, but you received nothing from the court offering you a free attorney because you don't have a constitutional right to one.
With all due respect, I wasn't snapping, but it sure sounds like you're snapping.
All right, we're done here today. You'll get notice of the date in the mail. If you want to retain an attorney, you're free to do so, Mr. Nosel.
Thank you. Have a nice day.
In the end, it appears Nosel's rejection of the offer paid off, because 3 weeks later, when the parties had another hearing, the officer who issued the ticket failed to appear, and the case was dismissed. Next, we're in Georgetown, South Carolina for a plea hearing. 62-year-old Raymond Moody has been charged with murder, kidnapping, and criminal sexual conduct. 13 years earlier, Brittany Drexel, a 17-year-old from Rochester, New York, had gone to Myrtle Beach, South Carolina, without her parents' permission, to celebrate spring break with friends. One night when she was alone, according to court documents, Brittany met Moody and his girlfriend, Angel Voss. The three went to a campsite, and after Voss left, Moody allegedly sexually assaulted and strangled Brittany to death, leaving her body in a wooded area. When Brittany's boyfriend didn't hear from her, he called Brittany's mother, who contacted police. Moody, a registered sex offender who previously served 20 years in prison for kidnapping and sexual assault, was an early person of interest. But he denied any involvement, and when investigators didn't have enough evidence to charge him, the case went cold. 13 years later, with the help of cell phone data, police were able to place Brittany's phone in the same spot as Moody's vehicle at the time she disappeared. Moody was arrested, and this time, when he was questioned about the case, he made a full confession.
What caused things to go? Nothing caused it but mine. Yeah.
He also led police to the location of Brittany's remains. Today, Moody appears before Judge R. Farrell Cothran to enter his plea and hear his sentence.
Mr. Moody, you want to plead guilty?
Yes, sir.
But before the judge imposes sentence, members of Brittany's family, who've waited 13 years for justice, deliver victim impact statements, starting with her adoptive father, Chad Drexel.
To lose her child, I mean, I'm gonna be her adopted dad, but I loved her. First, I thought she would be found, have her days turned to months, and those months turned into years. Years of torture, wondering where my daughter was. And now, 13 years later, I find out the horrible, disgusting, and senseless way she was abducted and murdered. Every part of my being wants to say and do something about that, but my heart knows that I will not, and Brittany would not want me to go to jail over that.
The last family member to speak is Brittany's mother, Dawn Plecken.
Today, my daughter, Brittany, is here with me. I wear her picture and her ashes around my neck, today and every day for the rest of my life. That's all I have left after what you did to her. What gave you the right to put your hands on my daughter? I ask you, Judge Cothran, to sentence Raymond Moody to the fullest extent of the law, to make sure his last breath is taken in the cage where he belongs, where he will never harm another beautiful girl like Brittany again. Thank you.
Next, Moody makes a statement and references both of his sexual assault cases.
I was a monster. I was a monster then. And I was a monster. And I took Brittany Drexel's life. I don't have the words to express how horrible I feel. And I've felt ever since that day. I'm very, very sorry. That's all I've got to say.
Finally, Judge Cothran delivers a few words to the defendant.
Okay, Mr. Moody, the acts that you did were horrific. And I hate it for this family and all the years they've gone through not knowing what happened to their loved one. And it's my job to sentence you appropriately. And on the crime of murder, sentence to the court as you committed to the State Department of Corrections for the term of your natural life.
For the kidnapping and sexual misconduct charges, Moody was sentenced to an additional 60 years in prison. He'll have no chance of parole. Moody's girlfriend, Angel Voss, cooperated with investigators and was never charged in the incident. Next, we're in the 31st District Court in Hamtramck, Michigan, for a virtual hearing on a civil infraction. 5 months earlier, 72-year-old Burhan Chowdhury allowed the grass and weeds on his property to grow out of control, violating a local law against noxious weeds and vegetation. Chowdhury was undergoing treatment for lymph node cancer that left him too weak for yard work. His son, Shabir, who usually maintained the property for him, was out of the country when police issued the ticket. Shabir cleared the overgrowth when he returned to the U.S. Father and son are hoping for leniency today from Judge Alexis Krott, considering Chowdhury's medical condition and that it's his first offense.
All right, you have a ticket for failing to keep the fence, walkway, sidewalk, or alley free of weeds, trees, or other nuisance vegetation. It's a first offense civil infraction. You can plead responsible with an explanation, or not responsible.
I am a cancer patient, very old man, and I am a cancer patient. I was then very weak, and very weak. And this time of rainy season, I cannot look after this thing.
Chowdhury's labored breathing is apparent as he explains how his illness and the rainy weather affected his landscaping. But the judge refuses to cut him any slack.
You should be ashamed of yourself. If I could give you jail time on this, I would.
The judge is not feeling forgiving. Quite the opposite. She's talking about jail time for an elderly cancer patient for a minor civil infraction.
If I could give you jail time on this, I would. The fine is $100, pay it by February 1st. You've got to get that cleaned up. That is totally inappropriate.
Oh my God.
Chowdhury is stunned at the judge's outrage. So son Shabir steps in to reiterate his father's situation and to tell the judge that the weeds are already cleared.
Oh, okay. Like, is it, ma'am, forgivable because my father is currently sick and we cleaned that after?
You see that photo?
Yes.
I am very sick, man.
That is shameful. Shameful. The neighbors should not have to look at that. You should be ashamed of yourself.
Yes, I am sorry.
You're going to jail.
Judge Krott closes the hearing with a threat to send Chowdhury to jail if he returns to her courtroom. The rant went viral within a week, with many reacting to Judge Krott's treatment of Chowdhury with disgust. An online petition calling for her removal from the bench has over 250,000 signatures. The judge released a statement apologizing for her behavior towards Chowdhury and reported herself to the Judicial Tenure Commission. The Hamtramck City Council later voted to censure Judge Krott. Chowdhury's $100 fine was paid 2 days after the hearing. Next, we go to Centerville, Michigan for a preliminary hearing. 66-year-old Rosalind Keenan has been charged with resisting and obstructing a police officer and driving with a suspended license. The resisting and obstructing charge, a felony, is punishable by up to 2 years in prison, while driving with a suspended license, a misdemeanor, could land her in jail for an additional 93 days. Keenan is free on $10,000 bond, and today she appears without an attorney before Judge Jeffrey Middleton to discuss next steps in the case.
Are you Rosalind Ray Keenan?
I'm here as sui juris in propria persona, Rosalind Ray family of Keenan, beneficiary.
Keenan appears to be making a sovereign citizen argument by refusing to identify herself to the judge.
I'm here under fraud, menace, and duress.
Judge Middleton checks in with the state prosecutor, David Marvin.
Mr. Marvin, is there a plea offer here?
What I would do is offer an attempt resisting and obstructing and dismiss count 2. And if there's no other incidents with law enforcement or any other reason to continue, I would dismiss this.
What would you like to do?
Are you asking me to take a plea?
I'm asking you if you're willing to accept the prosecutor's plea offer.
I don't understand that.
Mr. Marvin, let's just put on a
playing
plea.
games. I'm serious.
You are playing games, and first of all, you don't.
I'm trying to advance to
all right,
what
stop.
I'm here.
You don't interrupt the judge, whether you're a flat earther or not.
I'm not flat earth. So.
All right, well, this crazy stuff you're saying, I've got very little patience for it. You don't have an attorney, which concerns me because these charges could result in your incarceration.
May I ask what jurisdiction? Is this civil or criminal?
This is a criminal case, which points out the fact that you could use a lawyer if you can't tell the difference between a civil and a criminal case.
I have to know the jurisdiction this court is operating under.
Stop.
Sixth Amendment grants me the right to know the jurisdiction being applied.
All right, stop. If you interrupt me one more time, I'm going to find you in contempt and you're going to go to jail.
Objection, please.
All right, I find that you're in contempt. You're going to jail.
I'm simply
This matter
trying
is
to
adjourned and
exercise
tomorrow
my
at
Sixth
3
Amendment
o'clock.
rights, please.
Well, you can think about it
We can go
overnight in
forward
jail.
with this right now, please.
No, you're going to
I do
jail
not
for
wish to be
24
in
hours.
contempt.
I know you don't wish to go to jail, but you certainly
I
have
will
earned it.
continue with this if you please let me finish.
We'll talk about it tomorrow, and you will be more respectful to the court.
I
You
can
will speak-
provide the
You will not
citation.
interrupt the court. Your citations are meaningless.
I'm sorry I
So you
interrupted
can
you.
go
Do you wanna
with the
continue?
officer. I don't want to argue about it. Take
I'm
her
not
out of here. We will address this tomorrow at 3 o'clock.
The next day, after spending a night in jail, Keenan returns to court, but with a very different demeanor.
Would you like me to appoint an attorney for you?
Yes,
All right, I'm going to appoint an attorney.
thank you.
Keenan was released from jail, and Judge Middleton scheduled a follow-up hearing. The case is pending. Next, we're in district court in Ann Arbor, Michigan, for a virtual hearing. 3 months earlier, 70-year-old Ariana Megnot was driving her mother to the hospital when she was pulled over and given a ticket for going 50 in a 45 zone. The ticket carries a $120 fine, and even more significantly, would add a point onto Megnot's driving record. The prosecution has offered her a deal. If Megnot pleads to the lesser charge of impeding traffic, she'll pay a higher fine but receive no points on her license. She previously indicated she would take the deal. But today, before Judge Cedric Simpson, Megnot has some other ideas.
Did you wish to plead to the impeding traffic?
Yes, but Your Honor, is there any way you can dismiss the charges? This is the first time I drove faster because my mother was sick.
I'm not dismissing. My understanding is you were going to be pleading to the impeding traffic.
Well, sometimes too, Your Honor, when you're overstressed, my mother called, she's 95 years old, and I drove faster to take her to the hospital. I sort of lost it, and can you just let this go for once, and then I will be confident.
Okay, that'd be a no.
How much are the charges, Your Honor?
It would be, an impeding is what, 180?
Yes, sir.
Is 180.
Okay, Your Honor, if you're not accepting it, so I guess I back off, I pay for it. I tried.
I'm not doing anything. It's up to you. You can head to a hearing on the original speeding charge, or you can accept the people's offer of impeding traffic. Those are your two options.
I guess you're not, so I just pay for it. Is everything money, 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 Your Honor? I will pay for it. Money, money.
Ma'am,
Can't you just forget it for once?
Ma'am, I don't care about the money at this point. But if you think I'm up here and it's about the money, you are flat blasted wrong.
Judge Simpson now appears thoroughly frustrated with Magnot and moves to end the hearing.
So what do you want to do?
I waited 1 hour and a half.
Well, I've been up here 4 hours. So what do you want to do?
I will pay the amount, $180. That's it.
Do you want to plead to the impeding traffic?
Of course, I went faster than I should have.
Court will accept that admission of responsible. Fines and costs of $180. So when can you pay this?
Now.
Ooh, you don't want, you know what? You better check that attitude. You don't want to do that with me. Not today. Not today.
You asked me, I said now.
Yeah, sometimes it's not what you say, it's the way you say it. Pay it out at the counter. Pay it out at the counter, I'm done.
Thank you, Judge.
You'll take that case down there, make sure she pays it, get her out of my courthouse.
Judge Simpson carries on with the next case, but later discovered that Magnot did not, in fact, pay her fine that day.
Hold it, she didn't pay? That lady didn't pay? Where is...
She already left.
She already left? With my money?
Yeah.
After she...
But she said she didn't want to pay with cash. She was going to come back tomorrow with a check.
She's going to come back tomorrow with a check.
That's what she told me.
Okay.
Magnot did not return the next day with a check, but 4 days after that, she came to the courthouse and paid her fine in full. Next, we head to Woodhaven, Michigan for a preliminary examination. 62-year-old Wade Brito has been charged with armed robbery. 2 years earlier, police say Brito was in a big box store where an employee claimed he saw him stealing clothes. When the employee questioned Brito in the parking lot, the defendant allegedly brandished a knife before fleeing in a vehicle. Since the employee recognized Brito from past visits to the store, he was able to help police identify him. Brito was arrested and is being held on $300,000 bond. He's pled not guilty. Today, Brito appears remotely from the county jail before Judge Jennifer Coleman Hessen.
All right, Mr. Brito, the allegations are that you committed an act of robbery armed, which is punishable as a felony by up to life or any term of years.
When the judge is finished, the state calls its first witness, store employee Christopher LaFleur.
And on that date, did you observe anything that would bring you into court today?
Yes.
Okay. What, if anything, did you observe?
He was in electronics. He quick selected a couple packages of digital film. He then went to sporting goods and he had a hat on his head prior and he took that hat off, grabbed a new one, took the tag off, put it on his head. After the hat, he went to the apparel and he took tags off 2 pairs of pants and then he concealed the pants.
And did he pass all points of sale?
Yes.
Okay, and did you make contact with him?
Yes.
What did you say to him?
I told him that I just needed the merchandise back that he had concealed.
Okay, and when you got to the sidewalk, what did he do?
He reached into his right pocket and he brandished a knife.
Brito seems to disagree with LaFleur's testimony.
Okay, and what did you do as a result of that?
Oh, I got out of the way. He told me I had 2 seconds to back the off.
Okay, and were you scared?
Yes.
Were you in fear of your life?
Yes.
Okay, nothing further for this witness, Judge.
The defense then argues that if there was a knife, it was too small to be considered a dangerous weapon. But Judge Hessen disagrees.
All right, based upon the evidence that I've received, the testimony provided by Mr. LaFleur, the sole witness called by the prosecutor.
Brito, meanwhile, begins packing up his stuff.
I believe that the prosecutor has met his burden of proof with respect to the charge of armed robbery, and all of the elements were provided.
Brito is not happy with the judge's ruling and begins making comments under his breath.
Prosecutor established identity. Prosecutor established the date and place, location, and the requisite terms or elements of the charged crime, robbery armed. Again, there is a 4th offense habitual offender notice thereto, attached thereto, identifying April 10th of 1991 of breaking and entering an occupied dwelling conviction, December 17th of 19.
As Judge Hessen goes over the defendant's prior convictions, Brito turns his back on her, and The judge has finally had enough.
This is completely unacceptable that he has turned his back to me. Otherwise, I would have ordered him to be in this courtroom.
Bunch of liars.
Oh, I'm not finished yet. I'm not finished yet. No. Do not walk out. Do not walk out before I hold you into
do what you gotta do.
I've been very
You're gonna sit here and listen to all these lies, and you're putting lies on me, and everything that you got is a hokey-doke courtroom right there with a liar for a prosecutor, and you bring a liar in here to sit there and lie.
The judge ignores Brito's comment and tries to finish the hearing by going over his bond conditions, if he's able to post it.
Sir, you are not to return to or re-enter the premises of any store. You're required not to possess or have access to any firearms or weapons, and you are required to obtain a GPS tether home detention.
I'm not
With a
putting on no
curfew,
tether.
13 hours, and that's only in the event that you're ever released.
Whatever.
You're all set, sir.
Great.
August 1st at 9 a.m. at the Wayne County Circuit Court.
Have a Merry
Frank Murphy,
Christmas.
Hall of Justice.
Great.
Thank you.
Merry Christmas.
Thank you.
Thank you.
Brito remains in custody, and his case is pending. Next, we're in Lansing, Michigan for an arraignment. 67-year-old Giannina Ballerini has been charged with 2 counts of assaulting, resisting, or obstructing a police officer. A day earlier, Ballerini was at a local shopping center when she had a run-in with an officer. When she refused to cooperate, she was arrested. Today, Ballerini appears before Judge Stacia Buchanan to hear if she'll make bond. But things get off to a rocky start.
Are you Giannina Ballerini?
Oh no, my name is Courtroom bin Laden Mohammed Al Saud.
Oh, I don't have you here. I don't have a file for you.
Yeah, they're confused. My name is Courtroom bin Laden Mohammed Al Saud.
There appears to be some confusion about the defendant's name.
Your Honor, you have the right file.
I have the right file?
Yes, ma'am.
Well, you got the wrong person. And I said, call my husband, Crown Prince Mohammed Al Saud from Saudi Arabia.
The defendant is claiming to be the wife of Saudi Arabia's prince, 37-year-old Mohammed Al Saud. Judge Buchanan continues with the hearing.
So I'm going to read you the complaint.
Okay,
so
I
you
don't even know
know.
what the crime is.
This says that you did assault, batter, wound, resist, obstruct, oppose, or endanger Officer Erica Halfman, a police officer of the Lansing Police Department that you knew or had reason to know was performing her duties. That's a felony punishable by that's a felony punishable by 2 years in prison and or $2,000. And that count
It was a
2.
man that arrested me. K9. That's the one that complained. I didn't attack him.
You can't yell over me. It's my turn to speak. You're here now, and you've been arrested, and my job is to read you the charges.
My job is to tell you. You don't belong here.
Actually, that isn't your job. That's not your job.
On the bridge. Damn it. That's all.
Nope, that's not your job.
I don't know nothing. It's bitch.
This person is dangerously close to just being in contempt for saying bitch to the judge. You want to keep going?
The defendant remains quiet, and the judge moves on to the subject of representation.
Do you want a public defender to assist you in this case so that you can explain your side of it?
Yeah, I'm male. Not a female with glasses and I haven't been at a school maybe a month. I'm male.
You don't get the right to request the gender of the lawyer who assists you. That's ridiculous.
Call my husband, period. The Crown Prince that runs Saudi Arabia. And I'm Arabian, not American. So you don't own me, you understand?
Do you have a local address where you can receive mail?
Crown Prince, Saudi Arabia. Look it up. We don't give it away on the internet.
Ms. Schroeder, anything you want to add so that I can make a bond decision today?
Based on the lack of criminal record, I'd ask for a PR bond, but we need local information. That's all, for contact.
My husband, Mohammed, he runs Arabia, Saudi Arabia, the one you got oil for, free oil. That one, that dude. You idiot.
If the court's inclined to keep her in custody, I would ask that she be seen by psychiatric services. Thank you.
From now on, I'm gonna shut up. Don't even say a word. I don't know nothing.
Okay, based on the conversation here today, I don't believe that this defendant's going to appear for any future court dates. I have real concerns about the combative nature of what our discussion has been. So bond will be set at $10,000 cash surety.
Ballerini did not make bond and remains in custody. Her case is pending as she undergoes a mental health evaluation.